Hello, my name is Terri Antistdale, and I'm going to talk to you today about the Assigned Claims Plan of Michigan and a fraud statute related to that plan. In beginning this discussion, I'm going to talk about what the Assigned Claims Facility was, how it became the Assigned Claims Facility, and how it's changed over time, why those changes are significant, and how to utilize those changes. So the Assigned Claims Facility was established in 1973. It was put into place to give insurance coverage to individuals that were hurt in automobile accidents when there was no insurance coverage. So if between the injured party, the drivers of the vehicles, their resident relatives, etc., nowhere out there could there be personal injury protection coverage found, that injured individual could make application to the state of Michigan, to the Assigned Claims Facility, to have PIP-like coverage provided. It specifically provided for reasonable charges for medical care, recovery, and rehabilitation. And it was developed in conjunction and in accordance with the Michigan No-Fault Act. So back when the Assigned Claims Facility, this is prior to 2012, was in place, if a person was injured in a motor vehicle accident, they would simply contact the Assigned Claims Facility. Before 2012, the facility location was in Lansing, and a person would be given a very simple application. Most of them were turned in handwritten. They were about 2 pages long, simply asking about insurance coverage and the specifics of the accident, any injuries, any medical treatment, etc. There was not a detailed inquiry into eligibility, just a very cursory inquiry, and a lot of times ineligible claims were assigned to assigned insureds rather than being fettered out in that initial process by the Assigned Claims Facility. A determination would be made by ACF if there was any applicable motor vehicle coverage or not, and then a servicing insurer would be assigned to the claim. So somebody like Allstate or State Farm would be assigned to that particular claim, and they would handle it as if it were their own no-fault claim. So currently in Michigan, we have the following serving insurers, which is Allstate, Auto Club, Citizens, Farm Bureau, Farmers, State Farm, and Titan. What was the problem with the Assigned Claims Facility? Well, they didn't really have a vested interest in fettering out ineligible claims. The Assigned Claims Facility was governed by the Michigan Secretary of State. So a lot of times claims were put in this 2-page application. They looked at the application and would say, oh, there's no applicable coverage. Okay, we're going to assign this to an assigned insured. So prior to the claim being assigned, there was no documentation that was required to support the claim. So a lot of times these claims would come through to the assigned insureds, and there wouldn't even be a police report, let alone any type of medical records or any independent verification that a motor vehicle accident had in fact taken place, let alone dealing with the complex issues of coverage and priority of coverage. And there was probably the biggest downside was there was no authority to reject a claim due to insufficient information or documentation, and there was also no basis to deal with any type of material misrepresentations. As I indicated, prior to December of 2012, ACF was managed by the Secretary of State. The application, again, was very simple, and it was just a cursory review to see if there was insurance available. So if somebody would answer the question, do you have motor vehicle insurance? And they said yes, well then clearly that would be something that they wouldn't assign to a servicing insurer. However, if it said no, and there was nothing on the face of the application that would indicate that there was coverage available, the inquiry would not go further than the application. There was no statutory language which would be comparable to a provision in an insurance policy for fraud or misrepresentation. And the application for benefits was just very basic. It didn't provide any protection whatsoever from fraudulent claims. So what happened in December of 2012? Well, Public Act 204 was enacted, and it was a pretty big deal. it created MCL 531.71 through 78, and these basically established the assigned claims plan, which is the name now, that the governing body or the managing authority for ACP was no longer going to be the Secretary of State. It was going to be the Michigan Automobile Insurance Placement Facility. And this was going to be governed by a board of governors, many of which who are from the insurance community. And the location was actually going to move from Lansing to Livonia. So any claims for personal injury protection benefits are processed at this new assigned claims plan rather than the assigned claims facility, applicable in December of 2012. So when an individual is injured in the state of Michigan, if there's a motor vehicle accident and there isn't any applicable personal injury protection insurance, this ACP comes into play. It also comes into play if there's a dispute between insurers as to who might be in priority, or if you have an insurer who is not financially equipped to deal with a claim. Why is this change so significant? Well, the administration shift from Secretary of State to the Michigan Auto Insurance Placement Facility was very significant. It basically took the supervision away from an uninterested, unvested body in government and took it and put it with individuals who are from the insurance community, who are aware of the issues with regard to coverage, with priority of coverage, fraudulent claims, etc., and put them in a position of reviewing these claims and assigning the insurers. One of the major things that first came out when the Michigan Automobile Insurance Placement Facility came into play was that a new application came out, and there were several layers of protection from fraud and knowingly giving false information in that application. So there's an amazing website that you should check out if you're interested in seeing what's available now with the assigned claims plan, and it's up on the screen. How to contact them is up on the screen, and it lays out basically, it takes what would be policy language if there was a policy and incorporates it into the new statutory provisions that are in place. So knowingly making a false representation in an application to the assigned claims plan now can be handled much like a falsity in an application for no-fault insurance or in a claim for no-fault insurance, in that if it can be shown that it was knowingly false and it was material, then coverage can be denied. So that wasn't available before the 2012 amendment. On the website, there's a really good link to the application. It can be filled out online or it can be uploaded, and the requirements for determination of eligibility are really clearly stated. The application provides in bold print several of the statutory changes and things that people need to be aware of when they make the application. The section below is one of the direct quotes from the statute. It says, please be advised that the owner of the uninsured vehicle involved in the accident, even if it is the injured person's spouse or family member, must reimburse the MACP, which is Michigan Assigned Claims Plan, for all costs paid on the claim, which was caused by his or her failure to purchase auto insurance. Failure by the uninsured owner to reimburse the MACP for all expenses paid may result in suspension of their driver's license and or their vehicle registration. So this is one layer of protection. This basically jumps out on the application as a warning. Hey, if you're uninsured, or if it was your mom that didn't provide the insurance, or your sister or brother, whoever it was, you can go ahead and make this application and you can receive benefits, but know that the person who failed to provide insurance for that vehicle is on the hook to reimburse for those expenses. And by the way, if they fail to do that, we're going to suspend their driver's license or their vehicle registration. So it gives fair warning. With regard to MCL 500.3173A, this is basically the part of the statute that provides a misrepresentation or fraud provision that lacked before 2012. The Michigan Automobile Insurance Placement Facility is given obligations which weren't present prior to December of 2012. In Section A, it imposes a duty, a shall, to determine eligibility. So not just read it over and if everything looks okay, then you push it through. This imposes a duty. You have to make a diligent effort to determine if eligibility is appropriate in this case. And it imposes a duty to deny an obviously ineligible claim. So for instance, if the question is there motor vehicle insurance coverage? And somebody puts yes, they have a duty to veto that on its face. And below there is the actual statutory language that imposes those two duties. Section 2 is where the fraud and misrepresentation really comes into play. And it gives a lot of detail. There are some good things and some bad things to the statute. It deals with the fact that the application can be completed online. So a person who presents or causes to be presented an oral or written statement, including computer-generated information. So it takes away the argument, oh, I didn't fill out the application, my mom did. It takes out the fact that, I didn't fill that out on the computer. If you sign it, then you filled it out. And it allows the application to be computer-generated. The computer-generated application only came into play after December of 2012. So if that information is part of a claim, or in support of a claim to the Michigan Assigned Claims Plan maintained by the Michigan Automotive Insurance Placement Facility for payment or any other benefit, knowing that the statement contains false information concerning a fact or thing material to the claim, commits Fraudulent Insurance Act under MCL 500.4503, and that is subject to the penalties of MCL 500.4511. A claim that contains or is supported by a fraudulent insurance act as described in this section is ineligible for payment or benefits under the assigned claims plan. So basically this is saying if you provide us with knowingly false information that's material to the claim, we're going to say that you're not eligible. You're not going to get past the assigned claims plan, period. So they can just veto an application for that reason, which wasn't present before December of 2012. So how can we use this new ACP fraud statute? Well, the changing of the application was a huge step in the right direction. It asks questions which help to determine eligibility and which attempt to filter out fraud. So it has 5 pages now. It's not the 2-page little cursory overview from 1973. It's got 49 questions. It's also got 10 items that are bold, and those are the fraud warnings and the acknowledgments that the information is true and accurate. And the application also asks for additional information to be attached, so it requires supporting documents. One of the great things is that in bold, it states if the application is incomplete or unsupported, eligibility is denied. So you can't just have somebody that puts in kind of a lame attempt for eligibility. If they don't answer every question and attach all required documentation, they're not going to receive benefits. It will be denied at step 1. It actually has a box to mark indicating that the application has been read and that the information that you provide is true and accurate. And there's another box that indicates that the applicant has read the fraud provisions, and the remedy for providing any false statement that's material is denial of eligibility. So the good parts of the application are that it must be complete, signed, received with proof of loss no later than 1 year from the date of the accident to be eligible. So again, the no-fault acts requirements of like the 1-year rule are basically being incorporated into this application process. The injured party or a representative for that party must sign the application as well as the preparer. So this helps to identify individuals that are soliciting. The incomplete applications will be returned and will not be processed until and if they are completed. And again, the statutory obligation of denying obviously ineligible applications will be much easier to identify due to the type of information and the detail, quite frankly, that's required in the application. The MACP is not afraid to prominently display the fraud statute. The fraud statute, section 3173A, is actually word for word in bold print on the application. We need to embrace the use of this statute and include it in our affirmative defenses if it's applicable, and be willing to file motions for summary disposition when we have knowing falsities or fraud that's uncovered during discovery. Now, these are fairly new motions because obviously this came into play in December of 2012, and some of our claims are a whole lot older than that. But taking the statute to the court is how we're going to get the court to define the statute. So if the motion is denied, basically you're asking the court to say there's no coverage. Note the legal basis that the court relied upon in making their decision and file application for leave to appeal. Obviously only do that in strong cases because we want the legislature to create case law that defines the statute to our advantage and not to our detriment. We need to use it so that it can be defined and refined. If statements in the application are determined to be knowingly false during discovery. So there's an argument out there that because the statute says a statement that's made to the Michigan Assigned Claims Plan, that if it makes it through that initial review from the Michigan Assigned Claims Plan and gets to an insurance agency that's an assigned insured, that this statute doesn't apply once it gets that far, that it only applies to the application and review process. Once it's assigned, it no longer will apply, and that's simply not the case. It's important that we file those motions for summary disposition to make sure that we are having the statute and bringing to the attention of the legislature small things, small nuances that might be added or changed in the statute. There are some weaknesses with regard to this particular statute as it relates to fraud. The first one is that it kind of ups the ante. It uses the statement, knowing that the statement contains false information concerning a fact or thing material to the claim. It's basically increasing the burden of what we have to show to deny benefits. In a no-fault policy, the case law is really clear that policy provisions which prohibit material misrepresentations, those misrepresentations can be made without knowledge of the falsity, and silence or omission can be considered a falsity. But in our statute that we're talking about right now, it says that the false information has to be knowing, and that's a higher standard than what's required under a no-fault policy as defined by case law. It does not affirmatively state that the prohibitions continue once the claim has been assigned to a servicing insurer. And again, that means it says that the statements, when they're made to the assigned claims plan maintained by the Michigan Automobile Insurance Placement Facility. And I've had attorneys make this argument that when we're looking to plain language of the statute, it says that those statements have to be made to Michigan Assigned Claims Plan, and not that it also pertains to statements that are made to the assigned insurer. So if a claim gets out of the assigned claims plan and gets to, for instance, State Farm or Citizens or another one of the insurance companies that's on there, and they do some depositions and get more information, and they find out, hey, wait, this information is false, and they do the motion for summary disposition, there are attorneys out there who are saying, no, 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 this particular statute only covers the review by the Michigan Assigned Claims Plan. So if it gets to an insurer, the statute no longer applies. Otherwise, it would say to the Michigan Assigned Claims Plan and the assigned insurers related to the Michigan Assigned Claims Plan, and it doesn't state that. It's a weak argument, but it's one that has definitely been made And the bigger argument seems to be, or the basis that these motions seem to be getting denied, has to do with it's an issue of material fact, but the language of the statute certainly doesn't help us with regard to that knowing element, and things could be done to tweak the statute and make it a little more user-friendly. And it's important that we litigate the statute so that we can hopefully get some changes made to the statute that will be beneficial. So thank you for attending the Michigan Assigned Claims Plan and Fraud. And if you have any questions or concerns or would like to discuss this presentation with me, my contact information is on the screen, and I would be more than happy to assist in any way that I can. Thank you.